255-DM. We get counsel place their appearances on the record, please.
Thank you, Your Honor. Attorney Kyle DeBrucker with and on behalf of the plaintiff, Della Rollins, who is seated with me to my left on the screen.
Thank you.
Your Honor, Jordan A. Schoenbrod on behalf of the defendant, Brandon Mead, who last I knew was in the waiting room, and I do not see him.
I do see him on my screen now, so I believe he's here with us. Are you here, Mr. Mead?
Yes, sir.
All right, thank you. So it looks like we have counsel and the parties. Got a bunch of busy stuff going on with this case, so let me get it set up here in my file. Looks like we have a request for to set aside the referee's recommendation, and then we have a objection to the referee's recommendation. I believe that's all the same thing from the plaintiffs. So let me hear from the plaintiffs first, and then we'll hear from the defense, and then we'll see where we go from there.
Yes, Your Honor. Thank you. We are requesting a de novo hearing pursuant to MCR 3.215. Under that court rule, the court may conduct a hearing, take additional evidence, or order that the referee conduct a further hearing when necessary to properly decide the issues, and that's what we think is going on here in this case. The referee's recommendation rests on materially incomplete record, particularly as it relates to the child's school placement, which, as we all know, is a significant joint legal custody issue that directly implicates multiple best interest factors.
Let me interrupt you for just a second. I think that there's two steps to this process. One is that there was already an order entered adopting the referee's recommendation. Is that correct?
That is correct, Your Honor.
So you're asking me to set that aside based on some service issues that you had trying to get that objection here in a timely manner. Is that correct?
That is correct, Your Honor. And just for additional context, I think I even misspoke in my motion for reconsideration in that I believe I indicated that we gave opposing counsel notice on the 16th prior to the deadline. She was actually given notice on the 15th. We did overnight our objection to get to the court the next morning, and apparently did not get there until the day after the deadline. That's our own deal with UPS and as to why that occurred. But we would argue that certainly Dad has not been prejudiced by this delay. I think that's even more evident in the fact that he was able to file a response to our objection. So as far as I'm aware, because it was never brought up to me, I didn't notice that this was late until we got the signed order through a records request that we realized that there was a problem. So we would argue that nobody's been prejudiced by the delay. We're here today. And we would ask that, based on the reasons outlined in our motion, that the court could constitute the delay as an excusable mistake or neglect, however you want to word it. But I don't feel disposing of the objection and request for a de novo serves the children's best interest just because of a technicality.
All right. As to that limited motion to set aside the order based on the service issue, defense counsel, your response?
Well, Your Honor, I don't have that. Well, I see it now because my assistant brought it in because in my mail this morning, this motion to set aside. I see at the bottom of his cover letter, he says he emailed it to me. I presume November 5th, the date of his cover letter. I did not receive that via email. So I have not even reviewed his motion to set aside. I am aware that he is making that request. My position is, I see it in his motion now that he states his client retained him a couple days prior to the objection period. This is kind of her MO in this type of case. It's happened in motions before where she is not timely. She withdraws the motions after my client spends significant fees defending them. And so my position is that the court should uphold their order and that it wasn't filed timely.
Your Honor, if I may offer some quick insight, I also don't know the veracity of the truth as to what counsel just stated regarding, prior filings or being withdrawn. I will point out that even when I look at the register of actions, my client had less than 7 days notice for this evidentiary hearing. It doesn't even look like for this February or September 15th hearing, the actual notice of hearing was not prepared until September 9th. So procedurally, I think my client was at a disadvantage. I think that pertains both to this issue as well as the request for the de novo. But nonetheless, I do not think that dismissing this based on a technicality serves the children's best interest, the child's best interest in any way, shape, or form. And we're here. I do not know why we would not just continue as planned.
All right, I'm going to agree to set aside the order adopting the referee's recommendation because I do believe that plaintiff's counsel had it answer ready prior to the, or had an objection ready prior to the expiration of the time period. But there was an issue with overnight mail, which he has documented in his motion that appears to me to be, while he was skating very close to the edge as far as the time limit, he did take action, substantial action within the time limit that normally would have gotten the objection to the court within the normal time period. It was but for the court's efficiency, where I entered the order on the first day that it was possible to enter that order. In most courts, and quite frankly in this court, normally it would have taken a couple of days and the documentation would have been here in a timely manner. So for those reasons, the procedural technicality of it, I am going to grant the request to set aside the order adopting the referee's recommendation and find that the objection was timely entered, which brings us to, so counsel, if you would, plaintiff's counsel, if you would prepare an order that grants that motion for my signature, I would appreciate that. And then that brings us to today, where there is the request for a de novo hearing. So I'll hear argument on whether or not we should have a de novo hearing, and then we'll set, if that's granted, we'll set a time in the future for the actual argument. And because I've not had a chance to review the referee's CD or the video of that yet. So we'll hear some argument on whether or not we should have a de novo hearing. So I'll allow plaintiff now to argue that motion. Go ahead, sir.
Thank you, Your Honor. As I was just mentioning, this hearing was originally scheduled for October 15th, the referee evidentiary hearing. And then suddenly, I believe my client got notice on September 8th that the hearing was now being moved up to September 15th. The notice for that hearings was actually prepared on September 9th. And I think that leaves her at a severe disadvantage. She did try to get officials from both schools as well as other witnesses to appear for that hearing. Of course, she is not an attorney. I understand that she didn't know how to subpoena these witnesses, but I must say, even if I had 6 days notice of a hearing, I think it would be very difficult for me to get witnesses subpoenaed for an evidentiary hearing on such short turnaround. So with that, I think immediately she was at a disadvantage for this hearing. And first of all, the referee did not hear, because of this, testimony from any personnel at the child's school, the prior school, or the current school. Yet these are the individuals who teach, evaluate, and observe this child daily. It's not just based on subjective opinions of the parties. And we believe that these witnesses would have central facts under several best interest factors, particularly B, H, and J. Without that testimony, the referee clearly lacks a complete evidentiary basis to assess the child's schooling needs and whether or not the current school versus the prior school, who is better equipped to accommodate the child. Not to mention, the referee didn't hear any testimony regarding other options as well, such as other schools, homeschooling, whatever else there could be. I think it's also important to note that this objection appeared, or the recommendation, Your Honor, appears to be more heavily focused on sanction driven regarding my client and her procedural deficiencies in going about this, rather than what's actually in the child's best interest. So we believe that the Michigan courts have recognized that this de novo process exists to ensure that the judge and the referee can make the ultimate decision on contested issues based on a complete record, and that the court uses the de novo hearing to receive additional evidence where the referee's record does not adequately address the child's best interest. And that's what we think is going on here. We don't believe that this is a minor issue. The school placement is significant. It affects the child's stability, daily routine, connections, access to academic supports, which I think is clearly controlling in this case, simply because this child does have an IEP. And this kind of decision of this magnitude should not rest on a partially complete record. We are not asking the court to rehear this matter. We're not asking the court to relitigate. We're just asking to supplement additional testimony so that this court can make a proper decision in the child's best interest. At the end of the day, Your Honor, I think the process here was procedurally deficient itself in the fact that there was such short notice for my client to gather these witnesses for this hearing. And we would just ask that this court either send this case back to the referee in order to conduct some supplemental testimony, or this court can hear that on a de novo hearing. But we would ask that this court allow my client to present that evidence and testimony.
Defense counsel?
Thank you, Your Honor. First, I rely on all of the arguments set forth in my response to plaintiff's objection. The fact of the matter is Ms. Rollins failed to properly prepare for what was a 3-hour evidentiary hearing. She can claim all she wants that she didn't have time to prepare, but my client had the same amount of time. She filed to my office 3 days before the evidentiary hearing a list of proposed exhibits and witnesses. She failed to call witnesses. She failed to and I will disclaim my colleague did handle the evidentiary hearing. So to my knowledge, she did not submit any evidence at the evidentiary hearing. She could have raised procedural issues at that time or timeliness issues, and that was not done. In fact, now she's retained counsel just days before the deadline. And as we just went over, had issues getting an objection in timely. And now she does want to relitigate this whole case. Her whole 60-some paragraph objection sets forth what evidence she will present, what witnesses she would like to call. All of that would have been available and was available to her at the evidentiary hearing. She filed an ex parte motion trying to change the child's school. It was denied. My client did the same thing to try to prevent the change of school. That was denied. And there were several hearings noticed. My office had to call the court numerous times to make sure we were prepared and that what was noticed was actually what was happening that day. She could have done the exact same thing and failed to do so. The fact that she was underprepared for, again, what was a 3-hour evidentiary hearing, it would be prejudicial to my client if this court allowed another full-blown evidentiary hearing. Pursuant to MCR 3.215 F2, this court does have discretion to limit witnesses and exhibits that were available to her at the time of the evidentiary hearing. Frankly, I don't think a de novo hearing should be granted at all in this case, but if one is, I would request that they are limited to new evidence available after the evidentiary hearing, which frankly will only be detrimental to her because the child is not doing well in his current school. I also do want to point out that she continues to violate this court's order despite the referee's recommendation admonishing her for same. We are now going on 4 months of the child being in a choice of school of her choice only that only benefits her. The child, again, is doing extremely poorly, and for sake of arguing against my own argument of bringing up new evidence, this cannot continue to go on. We have a show cause motion pending, and I believe sanctions should be granted against her, and the child should immediately be replaced in Gaylord Community Schools.
May I have a brief response? Yeah, thank you, Your Honor. So first of all, I would caution the court as to allowing counsel to provide facts that have not been proven or testified to regarding how the child is currently doing. I will say that I think it's even more concerning that neither one of these parties actually reside in this district anymore. I can't even sit here and say today that this child could even be allowed back into the Gaylord School District. My client has sold her home, and it's not just as simple as, well, it's in this child's best interest that we limit this witness testimony. This court's job is to determine what is actually in this child's best interest. And the only way they can do that is to get a full record to review. I would say that these witnesses weren't available on such short notice, and I do not think any witnesses should be limited. I don't think that my goal here is not to have cumulative testimony. It's not to put my client back on the stand to testify to what she already did, but it would be my intent to take a few hours to get the people in here, and maybe the court's opinion changes, maybe it doesn't. But I think by giving my client less than 7 days notice for this hearing did put her at a disadvantage. I do think that's a violation of her due process. And at the end of the day, we don't feel in any way, shape, or form that any of this is to serve the best interest of the child rather than just sanction my client.
May I respond, Your Honor?
No. How is it that your client, plaintiff's counsel, didn't have notice, didn't have preparation time when she didn't bring the issue of changing schools to the court's attention until the end of August? How is it that she would not have proper notice that a hearing would be required and that witnesses and school information would be necessary when she waited until August the 28th to even file a first motion regarding changing school systems beginning the next weekend or after the next weekend, after the Labor Day weekend? So
Yes,
how
sir.
is it that she did not have sufficient time to file a motion and gather the witnesses and evidence that she needed during the entire length of the summer preceding her motion?
And I think that's a fair question, Your Honor. I think that just lends questions to the timeline here. My understanding is that my client had discussed this with the opposing party, and it wasn't until the end of summer that he indicated he wasn't okay with this arrangement. That's my understanding. And at that point, was well underway of already. I mean, obviously, she had to take steps to get this child into this school ahead of that filing. It wasn't until it was clear that he wasn't actually agreeing to anything and that this was a legitimate problem and that she learned what the process was that she did file that motion. And from when I look at it, it was kind of a messy start to the case, and the fact that there were several ex partes filed. The best procedure probably wasn't followed here, and hindsight is 2020. But nonetheless, I think that's still different. She filed the motion. I can't even say if she knew who the teachers were at the new school at the time that she filed that motion. But even then, in my experience with these school officials, they're not going to show up unless they do have a subpoena, and you get that advice from their counsel. So she filed this on the 28th, and then there was a hearing on the 15th. I still think there was no way for her to know when a hearing would actually be scheduled, especially since the original notice was for October 15th and then got pushed up a month. So that was just kind of unusual, I think, with the timing.
It was unusual because the court wanted to make a decision before the child was in school for any length of time, which is how that decision is supposed to be made. It's supposed to not jerk a child out of a school system and bounce it back and forth. And the court had no way of knowing which way the case was going to go. So we set it as early as possible so that we could make a decision that would not unfairly jerk the child around if a decision to the contrary was made. I think the court did everything in its power to make amends for the mess that the plaintiff created. We tried to have a hearing as quickly as possible so that neither side was prejudiced and the child was not clearly prejudiced by moving school districts. She's the one who made the unilateral decision to move the school districts without prior court intervention, which is something that just simply should not be done, period. She did it. She bears the consequences of that decision. And the consequence is there was a shorter timeline. That's not the court's fault, and it's not the defendant's fault. She had every time to gather the evidence during the summer. She didn't make a decision to go over to the Traverse City area or the Forest Schools area on August the 28th. She had that decision made many weeks in advance of that. So she's had plenty of time, in my view, to gather that evidence and to have those witnesses available ahead of time. The fact that she waited until the last minute to gather the evidence is nobody's fault but her own. So no, under the statute, I'm not going to give her the ability to call witnesses that she could have had previously. NCL 552.507, subsection B, subsection 6 says that a de novo hearing includes a new decision based entirely on the record of previous hearing, including any documentation submitted there. And that's what we're going to do. I'm going to make it on the information that was available to the referee at that time. The court has the discretion under that statute to prohibit the party from presenting evidence that was not objected to determine the referee's finding conclusive as to any fact that was not objected to, and to prohibit the introduction of new evidence or use of new witnesses absent showing that the evidence was not available at the referee hearing. I believe that that evidence was available at the prior referee hearing for all the reasons I've stated on the record. So I will grant your request for a de novo review. I will make that de novo review based on the information previously provided to the referee, and I'll issue my written opinion as quickly as possible thereafter. Defense counsel, if you prepare that second order with that ruling, I appreciate it. Is there anything else that we need to do today, counsel?
I don't believe so, Your Honor.
Thank you very much. That's all then.
Thank you, Your Honor.
Jack Savensky and Kendra Sewell, file 23-19419-DP.
Again, good morning, Judge Elliott Plumber, on behalf of my client who is just entering the courtroom right now.
Good morning, Judge. Joel Shaw on behalf of Jack Savensky, who's accompanying me here on Zoom.
All right, this is an objection to the referee's opinion and recommendations. I believe that was filed by you, Mr. Blumberg. You want to state those for the record, please?
Sure, Judge. The proceeding before the referee was unusual on a number of fronts, least of which was in the afternoon prior to the hearing, we received a call from the front of the court's office indicating that the hearing was being adjourned, that it wasn't going to go forward. Part of that was that there was a Michigan State Police investigation that was going on relative to some allegations. And so I informed my client of that. At about 4:15, we received a call back from the front of the court saying that referee legal was ordering that this matter would proceed. So we were, first of all, at a significant disadvantage going into the hearing based on the prior adjournment that was going to follow. But even at the referee hearing, we made a very, I think, clear and strong record as to why the matter shouldn't proceed. Again, referee legal disregarded my arguments or decided to go forward. One of the issues that we were there for had to do with alleged denial of parenting time during the preceding summer. We presented testimony that was pretty clear about the health concerns that existed in Mr. Savensky's home, the medications that were not being properly administered by Mr. Savensky. And the referee legal didn't find that those were compelling enough reasons to find her not in contempt and to order make up parenting time. So based on those two findings made by the referee, we filed a timely objection, and we were simply asking the court to allow us to have a de novo hearing to present in certainly more detail and perhaps in a manner that the court will find more compelling than the referee did. So we are asking for a de novo hearing.
Thank you. Mr. Schraub?
Thank you, Judge. I would agree with Mr. Blumberg on one point, and that is that we created a full and complete record at the hearing before the referee. I think the referee did actually kind of grant Mr. Blumberg's request to not proceed insofar as referee legal elected not to proceed with the ongoing parenting time issues. that being the parenting time issue subsequent to the summer of 2025. My client hasn't seen his daughter since September, the first part of September 2025, and that continues. The defendant here may not like the referee's decision, but I think that's all this really is, except that I also think that this is a thinly veiled attempt on the defendant's part to also extend this period of time where Mr. Savinsky has not seen his daughter. And ultimately, I believe that she should be sanctioned for that. You'll draw the court's attention to the referee's opinion and recommendation, page 2 at the bottom, second sentence of that paragraph. A finding of contempt and a fine would have also been recommended, but due to the procedural nature of this matter, a formal show cause hearing against the defendant was never set. So I think that's a clear indicator of how distinctly the evidence favored my client. I don't think that this is a proper objection. I don't think it should proceed. I think the court also needs to be aware of a couple other things. One, the state police investigation has concluded. There was no charging request. CPS visited with my client for the first time this past week. They've indicated that they're closing their investigation without any sort of abuse or neglect findings. And we are headed towards what seems to be another referee hearing based on the ongoing denial of parenting time that started the first week of September 2025. I would ask that the court deny the objection. And, unfortunately, we may find ourselves in front of you again on this ongoing parenting time request, but we're certainly going to find ourselves in front of the referee again. Thank you, Judge.
Thank you. Mr. Blumberg, what evidence, if any, that would be new from what was presented at the referee hearing do you have now?
Well, Judge, we certainly the prescribers of the medication for the child weren't available because we were told the hearing wasn't going forward. And I think it's important that the court address that. I mean, a representative from the front of the court called my office, spoke to me directly, and informed me that the hearing was not going to go forward the next day. I immediately called my client and informed him of that. And we called, when we made efforts to contact other people and to inform them the hearing wasn't going forward. And again, referee legal, Judge, part of the de novo process, I'm assuming, is that you would review the transcript.
I have done that.
Okay, well, what is, without asking you what you thought of that, I mean, I thought I made a pretty compelling argument of the reliance upon the front of the court's direction. Without no due respect to the representative of the front of the court, she apparently wouldn't have made that decision on her own. Somebody told her that.
I don't doubt what you're telling me, that there was a mix-up in communication as to whether or not the hearing was going. I don't doubt that at all. My question, though, is what was the result of that? And so I've asked, it appeared to me that you had a full opportunity to take examination of your client, and that was done. And I listened to all of that. Mr. Schra was able to put, I believe, his client and 2 other witnesses on the stand, and I've reviewed all of that. So my question is, what, if any, additional evidence would be available for a de novo review, or should I make a de novo review just simply based on the outcome that was, or the information that was presented at the referee hearing? So you said the prescriber of medication. I, quite frankly, don't doubt what your client said during the hearing, that in her words, 5 times more was used than was required. So is there any additional information that you want me to be aware of other than that was not contained on the referee's recommendation transcript?
Again, my understanding of the de novo process is the court would be amenable to hearing testimony that's gone on subsequent from the referee hearing. There is new medication, and my client's ongoing concerns about Mr. Savinsky's ability and willingness to learn how to properly administer the medication.
That would normally be true, but in this particular case, the referee limited his holding to the summer parenting time. And so I believe that I would be, at this point, limited to the summer parenting time issue. And so it would be that information about the summertime, not about anything as Mr. Shaw indicated, that from September forward during the summer, during the period after the summer parenting time. So any new information would go to whether or not there was a proper limiting of parenting time after Labor Day. In my view, this is all from the summertime only. And I think all of that information is there within the transcript or the video that I viewed of that hearing. So I'm asking, is there any additional witnesses or evidence other than this prescriber of medication that I've already referenced that I need to review in making a decision about the summertime only?
So is it the court's suggestion that you merely review apparently you've already reviewed the video.
I have.
Okay, so, I guess you can determine, independent of the referee's findings, whether or not his findings were supported by the evidence, whether they were appropriate, and whether it was an abuse of discretion. I mean, all of those arguments will be made at a de novo hearing. But again, I'm trying to read between the lines of where you're headed in this manner.
So I'm prepared, but that's why I wanted to know if you had, as to that limited time frame, whether or not you had any additional evidence that could have been brought in that wasn't brought in. But I do want to limit it to that because I think that's the only thing that the referee made a decision on. The only thing that I could do a de novo review on is what his limited opinion is.
The child's pediatrician would be available to testify and provide the court with, I think, relevant testimony about the procedures in medicating the child, the significance of not medicating the child correctly. Those were not presented to the referee.
Judge, I don't believe that there was ever any intention to call the pediatrician to the referee hearing. I saw no subpoenas to that effect, and as you know, physicians don't just show up willingly to court hearings. If Mr. Blumberg wants to blow this wide open, I'm happy to do it because I can present to the court that his client perjured herself on the witness stand. I have text documentation of that fact. So if you want to have a brief hearing so that you can hear from the pediatrician, then I will present the evidence I have, and the court can determine what to do with that additional information. But I don't think it fares very well for Ms. Sewell.
Well, I appreciate your predictions, Mr. Shaw. Thank you.
You're welcome.
Mr. Blumberg, was there any attempt on your part to subpoena the pediatrician?
No, not to subpoena, but we've had discussions in advance of the hearing, and then certainly I didn't follow through when I was told the hearing wasn't going to go forward.
Let me understand then that the information that you got from the friend of the court was that the day of the hearing.
Yes.
You were told it was not going to go, so you would have had to have
No. I'm sorry. It was the
All
day
right.
before the hearing.
the day before, but you still would have had to have a subpoena out for the pediatrician's testimony prior to being advised. I mean, I would agree with you if you'd had subpoenaed the pediatrician and then called the pediatrician off, and the pediatrician then said, hey, I can't come now that they've put it back on. I get all that, but it doesn't appear to me that you subpoenaed the pediatrician to have the pediatrician available for that day's hearing.
That's correct.
All right. Under those circumstances, I'm going to find that there should be no new evidence allowed because it would not have been, even if you would not had the error by the friend of the court staff advising you to put it on or take the hearing off and then put it back on, you would not have had the pediatrician there at that hearing anyway. And so I'm not going to allow that. So I am going to base the review, the de novo review, based solely on what the evidence was as it was presented to the referee. Mr. Blumberger, is there any additional argument that you want to make then as to how I should view that de novo review?
No, Judge, I think, again, Child Protective Services would, well, again, that I'm not sure that had any bearing on the summer denial. I know that there was concerns about the hygiene and the mold in Mr. Savinsky's home. The CPS individual would be able to confirm that. My client testified to that on direct examination at the referee hearing.
All right. Mr. Schraw, any additional argument as to the de novo review that you want to make?
No, just responsive to Mr. Blumberg's comment. I think that Miss Sewell had been in my client's home in years. So for her to complain about conditions, I think is a red herring. And as I said earlier, CPS was just in there earlier this week and indicated that they're closing the case. But I do think that that goes more towards this issue that's coming down the pipe in regards to the missed parenting time since September of 2025.
All right. I have reviewed, as I've indicated, the entirety of the referee hearing, which would include testimony from Jack Savinsky, cross-examination of him, Tammy Figiel, and Deborah Kuhn, which were the witnesses for Mr. Schraw, and then the testimony of Kendra Sewell, and cross-examination of her as well. So I have made copious notes. I've got about 8 pages of notes that I made as to that review. In my mind, the objections are by Mr. Blumberg, number one, that the referee's finding that the plaintiff's failure to properly administer the child's medication was not good cause to withhold parenting time is contrary to the great weight of the evidence. My review of the testimony was that there were 2 instances approximately a year apart that the defendant testified to involving misuse of medication or improper use of medication. In my view, that did not was not a pattern. There was no testimony of actual injury to the child. I cannot find any abuse or neglect. At best, it was a mistake by the father of the child, of Marley in this case. And so I do not find that there was any impropriety in the referee's decision as to the medication issue that would have given Ms. Sewell the appropriate time or reason to totally withhold parenting time that was court ordered for the summer. The next objection is for the referee's finding that the child's general health and safety while in the care of the plaintiff was not a basis to withhold parenting time, was clear error. There was testimony in this case that the father took the child to a festival when the child was sick, that the child had a fever 3 times at parental exchanges coming back to the mother from the father, that the fridge was bare, but then that was somewhat retracted when she said that she had only seen that before the child was born. Then the mother made allegations of mold being at the father's house, but again, there was no indication that that was true after the child was born. And then there was an allegation that the child threw up eggs and other breakfast products upon returning from the father's home to the mother's home, and that the child was basically reversing her potty training after return from the father's home. All of those things appear to me to be normal, natural kinds of things when you're dealing with a 2-year-old that is going back and forth between 2 parents who are having difficulty in their relationship. In fact, it appears to me that there's almost zero relationship between the parents. I do not find it to be unusual for the child to have a fever, to be taken to a festival when the child may be somewhat sick, or to have that going to the festival aggravate that. I don't believe that the mother knew whether there was mold or whether there was food in the fridge because she was not present and did not testify that she was present to observe those things. She merely made the allegation. And a child throwing up what it ate for breakfast is a thing that happens on a regular basis to 2-year-olds. Whether that's, as the mother believes, the father's fault, or whether that's simply the anxiety and angst of traveling between 2 parents who don't agree with each other in child rearing practices or have any sort of good relationship, that the child is experiencing the anxiety and it causes the child to have some medical issues. I don't see anything there other than that I can characterize as neglect or abuse, which in my mind would come to some relevance to removing the child in its entirety from summer parenting time with the father that had been previously court ordered. The third objection and the fourth objection have to do with addressing the Child Protective Services investigation. In my view, all of that has to go with to the issue of after the summer parenting time. There was no information at the referee hearing of any specificity as to what the Child Protective Services investigation was about. There were certainly claims made, but there's no facts adduced. And I believe that that should be left to the time period beginning in September and moving to today's date. And the mother will certainly be able to litigate that if she believes that that's necessary. This decision will not address that. So my de novo review of this matter is that the referee made the exact right decision. And for all of the reasons listed by the referee, I am adopting that decision as my own. Mr. Straw, would you prepare a short order to that account?
I will, Judge.
Anything else, Mr. Blumberg?
No, Judge, thank you.
Mr. Straw, anything else?
Nothing, Judge. Thank you.
All right, thank you all very much.
Good day.
Ms. Kraus, could you update me as to this matter, please?
Yes, this hearing was adjourned from September 25th when the $700 bond was reduced to a $600 PR bond with the following conditions. That the defendant presented, let me start over with following conditions. The defendant shall maintain employment. There's been no contact outside of a voicemail that I attempted to return when I was out of the office. Our office has received information that there's a potential new employer from National New Hire, but there's been no payments received. The second part of that, the defendant shall make payments to meet monthly support obligation. There was a payment received on behalf of the defendant on October 27th in the amount of $50, of which $10.19 dispersed to this specific case. The defendant was also to take steps to obtain additional employment if they're unable to meet their obligation through current employment. Again, outside of just National New Hire indicating she may be potentially employed somewhere else. And then again, she did present at our office on October 2nd when I was out. I did attempt to return a call to her on the 6th. A gentleman answered and indicated that he would tell her that I called, but there's been no additional payments.
All right, Ms. Mastow, what do you have to say for yourself?
I am working 2 jobs, and anytime I can, like she said, my sister-in-law is posting payments for me. They just got the income withdrawal information for quality in, but I also need that sent to the Baymont. I work 7 days a week, 2 days at quality and 5 days at Baymont. But I need the paperwork sent. And later today, I go pick up the Obama phone she has been calling, and then I will be able to call her. I do not have an actual calling phone right now. I'm using Zoom to be here. That is why she's not getting anything from me. As soon as I go and pick that up today, I will call her.
You're working 2 jobs, 7 days a week. Why haven't
Yes,
you
sir.
made greater payment?
I have made as much payments as I could other than me putting myself in my house. I managed to get, I'm renting a bedroom and a bathroom off of somebody, and I had to put a down payment to move into a place because I moved into Otsego County. As soon as I released from the jail, I have not left. I found a place here. I found 2 jobs here, and I'm trying to get it going for myself. The reason why I couldn't make more payments is because I had to put a deposit down on moving into something. So I'm not homeless.
What did you pay for your down payment?
I paid $500 for a security deposit, and I paid $400 for first month's rent.
When did you do that?
I did that on November 1st. I just got my paycheck and I have not been able to go over and make a payment yet, but that is one of the things on my list to do as I had to take today off for court anyways.
Did you notify the friend of the court of your two jobs?
I notified the friend of the court of the quality. I have not been able to get to a phone to notify them of Baymont yet. I have not been working at Baymont for I think it's day number 7 was yesterday.
What hours do you typically work at the Baymont and the Quality Inn?
At the Baymont, I get in at 8:30 in the morning, and it depends on how many rooms. Lately, I've been getting out at 3:30, 4 o'clock in the afternoon. And at the Quality Inn, we go in at 9 a.m. and we don't get out till 4:30, 5 o'clock in the afternoon.
And you're telling me that you don't have access to any phone during that time period?
Well, I don't really pay attention to phones while I'm at work, to be absolutely honest. I tend to just go and do my job. I'm sure I could have, if I would have stopped and thought about it, I could have called one of you guys. But when I get to work, I focus on work.
Well, here's the deal. You're not meeting your obligation to the court. So what do I need to do to make sure that you meet your obligations to the court?
I need the income withdrawal paperwork sent to Baymont, so that way they can start just taking it out of my check like they are at the Quality. The Quality already received one and she transferred the paperwork and she's already mailed it out to you guys. I don't know if you guys have received that yet, but she did do the income withdrawal paperwork for Quality already, and I need it sent to Baymont. And I was gonna call as soon as I get my phone, but we're in court. I might as well tell you to send that to him now. The Baymont one is a very recent move for me.
Ma'am, you didn't answer my question. I said, what do I need to do to get your attention to make sure that you're meeting your obligation to the court?
Honestly, at this point, I am trying to make sure that I meet my obligations. And if I wouldn't have had to pay for the security deposit and rent, you guys would have made more money.
It's not about making money. The court doesn't make any money.
No, but you guys would have been
This is
given
your-
more money.
This is your obligation. This is a requirement. This is not a, you get to do it after every other bill is paid. This should be the top thing coming off your list. And what you're telling me is you're blowing me off, and when it's convenient for you, you're thinking about maybe I'll contact the court afterwards. That's not how this works. If you want to go to jail, keep doing what you're doing. But from here on out, when I tell you to do something, do it first, not last. Have I made myself clear?
Yes, sir.
Your Honor, I do have a couple concerns regarding this. She's indicated that she's in Otsego County now. We do
Yep.
not have an address for her. I did review the file. I don't see the information that she reported, the employment. I'm unsure if National New Hire has indicated if Quality Inn is the actual employer because it's an incorporated. And I would need more information in regards to Baymont to be able to send that as well.
What more information do you need?
Do you have a copy of your pay stub so I can make sure that the federal tax ID is the appropriate one to send it to the correct place?
Not with me, but I can email you one.
All right, so friend of the court needs current address, needs employment information. Is there anything else that you need, Ms. Kraus?
I believe, I guess once she obtains that phone to make sure the phone number that we have on file is the correct number.
Yeah. As soon as I get to my phone, I will give you a phone call so that way you can know that I'm the one that has it and you can call me instead of you getting the mail that answered in the first place.
All right, and how much is, Ms. Kraus, how much is she supposed to be paying each month?
Her obligation is $86. The balance on the account right now is $2,132.03. There's only been $65.16 received so far for this calendar year.
All right, and when would you like to receive a phone call from her, Ms. Kraus?
I'm uncertain as to when she's obtaining the phone. I mean, I would have liked one yesterday, but I don't
Yeah.
know when she will have that.
I will be getting it after 3:30 today, so if I do not get it before you shut down today, as it is Friday, I will call you Monday morning.
First thing Monday morning at 8 a.m.
Yeah, because I work at 9, so you will have to get it first thing.
All right, here's what we're gonna do. Ms. Masta is gonna make a phone call to a friend of the court, speak with Ms. Kraus Monday morning at 8 a.m. At which point she will give the friend of the court her current address. She will give all necessary information as to her employers, including federal ID numbers, paycheck stubs, etc. She will give the proper telephone number, and she will indicate when she is to make, when she will make her $86 payment for November. We're going to adjourn this matter for 30 days to December, at which point Ms. Masta will also have made a payment for December prior to the next court hearing. So Ms. Masta, do you understand what you're required to do?
Yes.
All right. Hopefully by the December court hearing, there's income withholding orders in place. If not, we'll adjust things accordingly. Once the income withholding orders are in place, things should go smoothly. But until then, Ms. Masta, you are required to meet your monthly requirements. And if you fail to do so, I will treat it as contempt and hold you in contempt, and I could consider jail time at that point. Do you understand what I've said to you?
Yes, sir.
All right, that's all for today then. Thank you.
Thank you. You have a good day.
Two.
Yes, this hearing was adjourned from October 24th. This specific case is arrears only. The balance is $2,327.44. This hearing was to monitor the defendant's compliance with the requirements. The first was to make a specific monthly payment of $50. Our office received a payment of $30 in October, and as of yesterday at shortly after noon, there has been no additional payment. Second, the defendant would obtain employment and report it to the friend of the court within 30 days, or the court would find the defendant in contempt and commit them to 7 days in the Otsego County jail. There's been no employment reported as of yesterday.
Mr. Gonzalez,
Yes, sir.
what's going on? Why haven't you made
I'm
your payments?
excited. First of all, I
I'm
want to
sorry,
tell you thank you. First of all, I want to tell you thank you for pushing me to be a better guy. I finally got a little job, so I'm kind of excited about that. Today's my first day, and these will be running smooth now. I'm excited. I didn't think I can do it, and you pushed me to be a better guy, so I appreciate you.
Where are you working at?
Right here at the still military base. We're doing a roof here.
What's the name of your company?
See ya. I don't even know the name. My first day. I'm gonna get all the information after I meet the boss, meet the owner. I'm up here
How'd you
right
get-
now with all the guys working. So they're gonna give me a week trial, and they like me already, but I'm a good worker, so they keep me, and then you'll know. But I know they're gonna keep me because I love to work.
Well, I'm glad to hear that. That's a step in the right direction. You still owe
Yes.
$20. You still owe $20 for this month's payment, and you need to contact the friend of the court to tell them what job you have. When are you going to do that?
Yes, sir.
When are you going to do that?
I'll do that sometime today. Actually, we won't get up till 5. The court's closed at 5. I'll have to figure it out, and I make sure they're gonna keep me. So I'll let them know more as soon as I find out more. As soon as I actually meet the main guy that hired me. I went through a foreman, and he called his boss, and they hired me on. I started this morning at 7 o'clock in the morning.
All right. So do you have a cell phone, Mr. Gonzalez?
Yeah, yes, Your Honor.
All right. Today is Friday. I'm going to expect a phone call to the friend of the court. by Friday, the 21st, November 21st, that's next week, Friday. And if you're working full-time, you should get a lunch hour. So I want you
Right.
to call by 1 o'clock, no later than 1 o'clock on Friday, the 21st. And I also expect a
week.
$20, that's next week. I expect
Yes,
a
sir.
$20 payment by then. If you
Okay.
don't, we're gonna hold you in contempt of court and I'm gonna issue an order sending you to jail. Do you understand?
Yes, sir. I got you.
All right.
Sure.
I'm glad that you've got a possibility of a good job there.
Yeah,
That'll
I'm
be a
excited.
good
I'm
thing.
excited.
All right, well,
Yep.
get your payment in, get your information in, and we'll adjourn things until the 21st.
Maybe soon I won't have to see you no more. Just making my payments.
Don't take this the wrong way, but I'm looking forward to that day.
Your Honor.
Yeah, me too. I thought
Right.
at first I was
Ms.
getting
Kraus?
upset with you, but man, thank you for pushing me. It made me be
I do
better.
want to indicate for the court record that we just need to make sure that this job is a job that potentially is a W-2. So we would need that federal tax ID number because if he's being paid as a 1099, it would fall on his responsibility to make those payments.
You understand what she
understood
just said, Mr.?
Yes, sir.
Did-
I think I'm
All
not
right.
too sure. I'm gonna find out more. I think it is a 1099, but I'm gonna find out for sure. And I will let the lady that just spoke her, I forgot her name. I'll let her know
This
what's
is-
going on.
All right, good. Hang on for just a second because we've got another case with you and I want to just put all of that on the record as well. So hang on just a second.
Thank you, Your Honor.
All right, the next matter is Melissa Reichstroff versus Jesse Gonzalez, file 18-17322-DS. Ms. Kraus, can you update me as to that file?
Yep. With this file, it was the same requirements. Specifically though, with this, his monthly obligation is $321. The defendant paid $200 on October 13th. There's been no payment for this month and then the remainder of last month. And then the current balance on the account is $8,585.98.
All right. Mr. Gonzalez, on this case, I'm gonna do the same thing. I'm gonna give you till next Friday at 1 o'clock to contact a friend of the court with all of your new employment information.
Understood.
And you need to catch up on your payment. So I think there's about $100 and some left that you need to pay. I don't know exactly. I didn't do the math
Yeah.
right.
Yep. I get paid next Friday too, so I'll better drop some money. I have a little bit of money now. I just haven't had it right over there, but I'll try to make it. I'll talk to the lady, see if there's any way I can arrange it, or I can just pay it the electronical way. That way it'd be easier for me to do it like that now that I'm gonna have a job.
That's a great idea. So you know what you need to do on both of these cases, right?
Call on the 21st.
Yep. And make
Got
the
you.
payments on both, of them.
Yes,
And then
sir.
we'll reschedule this for a month from now to monitor that you're doing what you're supposed to be doing and you still have your employment. And if that's true, we may be able to cut you loose at that point. All right.
I appreciate you and thank you for pushing me. At first I was very upset with you, but you know what? You pushed me to do something better. I appreciate it. Thank you.
I'm glad to hear that. Good luck to you, sir.
All right. You have a good day. Bye-bye.
You too. All right, this is the matter of Naomi Keaton and Brian Frazier. It's file 20-18252-DC. Ms. Keaton, this appears to be notice of hearing for arraignment on a bench warrant. The allegation is that you failed to appear on a hearing for December the 9th of 2024 for a show cause hearing, and a bench warrant has been issued with a cash performance bond of $600. Ms. Kraus, could you update me any additional information?
Yes, the plaintiff's obligation is $235. The current balance on the account is $5,280.52. There has not been a payment on this case till the Uniform Child Support Order entered in February of 2024. We did receive a letter requesting for this hearing to be addressed. As she indicated, she's been in the Antrim County Jail since July 11th. Otsego does have a hold on her as of right now.
All right, Ms. Keaton, how long are you anticipating being in the county jail?
I'm not sure yet. I don't get sentenced until December.
But you've been in there since July?
Yes.
What kind of a case are you incarcerated on?
A possession.
What do you anticipate will be the likely sentence once you receive it in December?
I'm not sure. My guidelines are 0 to 11 months. So I'm not sure if I'll be getting probation or more jail time or time served.
All
Your
right.
Honor.
Yes.
Based on that information, friend of the court, wouldn't be opposed to recalling the bench warrant and adjourn to February 13th in front of your honor. We would request, though, that the plaintiff contact friend of the court upon her release. And then we would also request that she update by a change in personal information form that we could fax to that jail to make sure we have the correct address and contact information.
Do you believe that based on her, the time that she's been incarcerated, an abatement for that period of time would be appropriate as well?
Not based on the child support formula guidelines. It hasn't been over 180 days as of yet.
All right, so I guess it would have to be through January. My only concern is that we won't know for sure if it's over 6 months until December, and that way she's been unable to work for the past, at that point, it'll be 5 months. And the only issue, I believe, is whether it's likely, not whether it actually is 180 days. So in my view, she's likely to get 6 months or more. We can always review it in February at that hearing to determine if it needs to be put back on. So let's do what you proposed and abate her child support, set it at 0, commencing in July. And then we'll review it in February. Ma'am, the upshot of this is we're going to recall the bench warrant. Ms. Kraus, does she still have a hold on Otsego for other purposes, not this bench warrant?
I'm not sure if she has other matters. I can only indicate for sure that it is, at least for the friend of the court matter. I'm not sure if there's any criminal matters.
All right. Ms. Keaton, are you aware of any other criminal matters that you have a hold on you for?
No, sir.
All right. Well, I'm going to take down the bench warrant based on your incarceration and the length of time that you've been there. I'm also going to abate, which means to stop the child support temporarily because of the time period that you've been in jail and are likely to have been in jail. And we'll review that in February. The friend of the court's office is going to send a form to Antrim County so that you can notify them upon your release of what addresses or address that you will be at, and so that they know how to get a hold of you, and so that they can conduct that review in February. If you fail to appear in February or don't send in the notices of what your new address is going to be, we'll simply issue a new bench warrant. We'll pick you up and you'll be back in the same circumstance that you're in now. Any questions that you have?
No, sir.
All right. Let's do that then, Ms. Kraus. Thank you very much. That's all for today, Ms. Keaton.
Thank you.
This hearing was adjourned from October 10th. Our office was to submit a petition regarding an ordered on arrears. Since that hearing, the $1,400 bond was released and applied to the case. The balance after that is $3,539.02. The petition recommends that the plaintiff's obligation be $468. The sum is composed of $312 for current support and $156 for overdue support pursuant to the Michigan child support formula, as it's no more than half of the current support.
All right. Have you had any contact from Mr. Gentz, Ms. Kraus?
I have not had any contact with him.
All right. Ms. Lambries, have you had any contact from Mr. Gentz?
I have not, other than my son does some side jobs with him here and there, but no.
All right, you've heard what the friend of the court has said. Do you have any objection to what they're recommending?
No, I don't believe so.
All right, do you understand what they've said? Basically, they're gonna add on to his monthly obligation $156 a month to go towards the arrearage that he owes you of 5,000 or 3,500 and some dollars. So you should be getting an increase in the amount once he starts making some payments on those.
He
Had-
doesn't pay it anyways.
Well, I hear you, but we're trying at this point to get some dollars to you. And the friend of the court will continue to take enforcement action against him if he fails to make this new payment. But we're up in the payment schedule so that upon his hopeful payment, it'll speed up the process. Any questions that you have?
No, other than just going forward, because he hasn't himself made a payment other than from when he got picked up for the warrant. And then before that, it was an involuntary payment, I think from a tax return. These upcoming court hearings that we're gonna have for non-payment, I don't have to be at, correct?
That's
'Cause-
correct.
Okay.
You're welcome to be here, but you are not required to be here.
Okay, I work at the hospital and it's not easy for me to get to these. So if I don't have to be there, I just want to make sure that was accurate.
Yep, and you can call into the friend of the court's office anytime that it is convenient for you to get what the status is, or if you have any questions, okay?
Okay,
All right, thank you, ma'am. Ms.
Thank
Kraus,
you.
I will adopt your recommendation in the petition for $312 of current support to continue and setting the ordered on arrears amount at $156 per month for a total payment of $468.
Do you
Thank
request to adjourn this out to monitor? Because this was a show cause as well. Or would it be
Yes.
recommended for a bench warrant?
So he's only made when was the bond forfeited?
Yep, the bond was forfeited at the October 10th hearing. A quick brief history of the case. $3,978 was received in 2025. Of that, only $700 has been received from the plaintiff, which was the $380 in June, $320 in September. Outside of that bond, the other amount consisted of a non-voluntary payment of almost $2,000. He has reported he's been working as a 1099 employee since at least April of this year. He has had the ability to pay and has not paid.
Yeah, he failed to appear today. He's failed to appear in the past. Let's do a bench warrant on him.
$900 plus $100 in court costs based on the form or on the standards.
Yes, please.
Thank you.
That's all for today, Ms. Lamberts. Thank you. Looks like we were here on a show cause. Ms. Kraus, could you update me as to that, please?
Yes, this hearing was adjourned from October 24th. The defendant was to make a $75 payment to the friend of the court by 4:30 on October 24th. He did. And it was also indicated the defendant is expected to make specific payments each month to meet his support obligation. If not, the court would find the defendant in contempt at the next hearing if he fails to comply. We did recently on November 13th. The defendant did pay $86 by specific payment. That was a combination of cash and credit card that's still pending disbursement. Because of the specific payment, it should be applied to this case. His obligation, though, is $200, which does include overdue support. Current support is $144. $56 is towards the overdue. The balance on his account is $9,168.49. The defendant hasn't complied with any support enforcement orders except for a payment back in May of 2025 of $80. At that point, it was paid to be released from jail. We're just seeking enforcement of the order as he's failed to comply.
What do you have to say for yourself, Mr. Kronk?
Your Honor, for those couple months, I was incarcerated, and I've had issues back and forth, like I said, with I got arrested and I was put back in jail for a little bit because the courts messed up on a no contact. But things are starting to pick up. I started working for a friend and I'm starting to get money. It's just hard for me to get to Gaylord to make payments to you guys because I have no driver's license or anything like that. And I really don't have anybody because I'm not gonna lie, I've been sober for 2 years now. And it's pretty crazy when you're sober, all your friends tend to die off. And it's pretty rough lately. You know, I mean, I can make another payment. I just got to try to get over to Gaylord because it all depends on how much I get paid, when I get paid. And the jobs are starting to pick up. I could probably pay the rest off. Maybe, I mean, I could call somebody today and see if I can get a ride back over to Gaylord, but I might be limited. It's just, I have a friend that goes over there every now and then to see family and they give me a ride. I got probably $40 more I could probably pay on to my child support. Right now, it's just with the job that I'm starting to work, it's just starting to take off. I mean, thankfully, I got something for employment because I got holes in my home right now, and they're talking about over $4,000 worth of repairs, and I have no idea how I'm gonna figure that out with 4 kids in my house and holes in my ceiling from a tree.
Mr.
But
Kronk,
thankfully, it's starting to take off.
Mr. Kronk, you were released from jail in beginning of October, right?
October 7th, Your Honor. And then I spoke to you on the court that day, and then I paid that $70. You told me I had to pay the $70 before my next court date, or I was going to go to jail. And I came in to pay the $86 yesterday. And if I was going to ask the court if you can give me till maybe Tuesday or Wednesday of next week, I could make the rest of the payment. I just got to find a way to get over to Gaylord to pay it to you guys directly at the courthouse. My only issue is I can't pay it over the phone with you guys. But I could pay the rest of the balance for this month. That's not an issue. I just got to figure out how to get over to you guys. I'm currently, they took my driver's license, Your Honor, so I can't drive. And it's really frustrating because I got Charlevoix County, I got to pay child support over there, costs over there, and literally like right now I don't have any money to my name to even buy myself any clothes, work clothes or anything like that for this new job or anything like that. It's pretty much, it goes everywhere to the courts over there and to you guys. And I mean, it's not an issue of paying the money, it's just the issue of getting over there. So I'd ask the court, please respectfully, if you could give me the next week, I can pay the rest of this month's obligation because I can't afford to go to jail with my employment just starting to take off.
Ms. Kraus,
I mean,
I'm sorry, Mr. Kronk, let me talk for a minute. Ms. Kraus, there is a independent payment place called MISDU in Lansing, right?
Yes,
So he doesn't need to come to Otsego County?
he doesn't need to, because he does have
Awesome.
more than one support case. Payments that are made will be dispersed based on those guidelines.
Sorry, looking for a pen.
I just know that he's indicated since May that he's had a job or a potential job. And it seems every time we're back here, he's requested an additional exception to the case, and then it's just resat.
Well, I'm actually able to make my payment, so I can get verification from him if you guys would like. I can get something from him in writing saying that I work for him, if that's what you want, or if you want me to have him call you guys directly and speak with you guys about it, I can have him
Mr.
call you
Kronk,
and
Mr.
notify
Kronk,
you
what I
guys.
want, Mr. Kronk, what I want is for you to pay your bills on time, every time. That's all I want. I don't want to
Okay.
talk to anybody else. I don't want to have verification from anybody else. I simply want you to make your obligations when you're supposed to make them. And so far you haven't.
All right. What was that? What was that? What was that website or the place you said that I can make it directly?
Ms.
If
Kraus,
you don't
do you
mind
have
me
that
asking
information?
again.
Yes, it's MISDU. He has received information in regards to how to make payments with pre-show cause letters that he has received. I do see that between the two cases, and again, it's neither here nor there, but his obligation for both cases just to comply with what's ordered is $398. But again, any payment being made would disperse. But
That's
looking at
that's the
his-
hard part because they. Sorry, I didn't mean to interrupt you. I was
Looking,
when you guys just now informed me of this one because I've always had to come over to you guys to pay. I didn't know that there was a direct line, so I could probably make a payment.
you can
today,
make
if you guys can
payments
give me
by
the rest of the
credit card as
information.
well, but in regards to that, again, they are set to the disbursement unit and there are dispersed based on the guidelines. Looking at the history of the case, the only payments that have came in recently for either case are the specific payments that have been requested per this order.
Because I've been in June. I've been incarcerated since June of last year, or this year. Because last year I had the issues, and this year I got the stuff with the driving on suspended. So I was incarcerated for a while, and then everything up till October. I mean, but everything's just now starting to take off, thankfully. And I mean, like
All
I
right,
said,
here's
now
what-
that I got this information, I can make a payment to you guys over phone and stuff like that. But I mean, it's just starting to take off. I can't afford
right,
to lose
Mr.
my
Kronk.
payment.
Mr. Kronk, I've heard you say that 4 times now, and I understand it, and I've heard you, okay? So here's what we're gonna do. I'm gonna give you, we're gonna reset this matter for a month from now, so the middle of December.
Okay.
You're gonna have to make your payments in full on both cases. So Ms. Kraus, that's that $398 total, is that correct?
Yes, it appears the monthly charging is $292 and there is the overdue support of $106. So it appears, yes, $398 would be what would need to be the case. Yes.
And that would be this case
That's
and his
just
other
sure,
case, just this case.
That would be
No.
both cases combined. What I did was do a search with his individual ID. So the total monthly charging, the obligation is $292. And then the ordered on arrears, which the system may have factored in something specifically for the other case. But again, even if anything is paid over, it would just disperse towards
I
arrears
would see.
cases.
I put in a reevaluation for you guys and for Charlotte County too, because I have 6 kids total. I have 4 that currently live with me, and it's rough. I got 4 children that live with me that are under the age of 5, and issues with this house. And everybody says call FEMA and this and that and that. There's places that'll help you. That's the biggest load of crap I've ever heard in my life, because literally this tree came through my house and there's nobody. DHS, everybody, and it's just. Pardon my language, it's a shit show. And it's crazy. I know things have been rough, and I get incarcerated for possession of drugs, and I didn't have nothing in my system, anything on me or anything around me. I'm standing not even by anything, and now I'm fighting for my freedom.
Mr. Kronk, I can't do anything about your criminal cases, all right? So here's what I'm gonna do. I'm gonna give you a month to pay your $398 per month. If you don't do that, I'm gonna put you back in jail.
Wait a minute, it's not 398 at all.
It is
It's
on all your
it's
cases.
200. It's 200 to you guys. My obligations with Charlotte County has nothing to do with Otsego at all. So that's not a factor in our case at all. You cannot factor my payment of Charlotte County in with your county, because that's a whole total separate case. My obligation and my cooperation with them has nothing to do with my case in Otsego. So that's not at all a possible or anything that goes by Michigan court rule that you can honestly add my Charlotte County case with my Otsego. That's irrelevant to our case. Whole totally
Ms.
different
Kraus?
trial.
Ms.
So
Kraus,
my
how much
support
is
with
it?
you guys is $200 a month. So that's what my obligation to you guys is, not $394 a month. I'm not
Ms.
paying
Kraus?
Charlotte County to you guys. I
Mr.
pay Charlotte
Kronk?
County directly to
Mr.
themselves.
Kronk, I've heard you. Every time I try to start talking, you keep talking more.
I apologize.
So just take a breath and let me have a moment. Ms. Kraus, how much does he owe in arrears?
On the case for our county,
Yes.
the arrears balance is $9,024.49.
How much is he paying in arrears towards the arrears monthly?
Just recently with the ordered on arrears is $56.
So what's his total monthly amount for us, including his ordered on arrears amount?
$200, $144 for current support and $56 towards arrears.
All right, Mr. Kronk, you owe me $200 before the date of the next court hearing, which will be sent to you in the mail. That'll be in December. If you don't pay that $200 between now and the next court date, I'm sending you to jail for 7 days. Do you understand what I've just said?
Yes, sir, I do.
Make it happen. I don't want to hear any
All right.
other excuses about your house or your criminal case or anything else. Make your payment. That's all for today.
All right, thank you, Your Honor.
Jessica Lounsbury Burns versus Jonathan McMurphy. That's file 12-14631-DS. You see Ms. Lounsbury Burns. Mr. Brown, is this your matter?
It is, Judge.
Ms. Spillane, is this your case as well?
Yes, sir.
Could you update me on this, please?
Absolutely. So the plaintiff was arraigned on October 22nd. The bench warrant was recalled and bond was reduced to a $1,200 PR bond with the following conditions. The plaintiff was to inform friend of the court where they were going to go to detox, which she did do. And then she must inform us when she was released, which she also did. And then you ordered her to do 10 weekly job searches, which she did do, and she was ultimately hired. And then she was also, prior to November 4th, to provide documentation from a doctor or detox facility regarding her diagnosis, work restrictions, and any kind of follow-up requirements for a friend of the court. We have not received anything regarding that. However, with her now being employed, we're just waiting for the income withholding order to become active. And she understands that she does need to make payments until that is active.
Mr. Brown, what do you think we should do?
Your Honor, if I could inquire as to what the payments are, and is this an arrearage payment as well, or are these just straight payments?
My apologies. Her monthly obligation is $256 with a balance of $7,372.34.
And do you know, or maybe this would be something for Ms. Burns, when this withholding order would go into effect?
It can take 6 to 8 weeks depending on the employer.
Your Honor, I would ask to have the matter adjourned out. Well, when is the last payment? When was the last payment?
May of 2022.
Your Honor, I would ask the matter to be adjourned out. It does appear they had a lot for her to do. For the most part, she has done all of those things. She did put out her application. She did obtain employment. And that should give her an opportunity to start making those regular payments by herself for at least a few weeks until that withholding order kicks in.
Ms. Lounsbury Burns, is there anything that you want to say on your own behalf?
I tried to get my doctor to send you guys and stuff. Yes, I've been working, I'm gonna keep working. I'm really sick. And I haven't had a job in a while, but I'm gonna keep going. It made me really sick. I'm breaking out with my MRSA. I'm gonna continue until I can get help from my doctor.
Okay.
It's gonna be tip wages mostly.
I'm sorry, I didn't hear that last part.
I'm a server, so it's gonna be like more tips. So as long as I can get better and not be so sick when I go in, I just want my full paycheck taken.
Well, I'm glad that you have got a job. That's good progress. So I think I am going to do what your attorney suggested, which is adjourn this out. Let's do that for 8 weeks. So 60 days. In that period of time, ma'am, if there's no income withholding order from your job, you'll need to make your payments on a regular basis there. And at the end of the 8 weeks, I'd like the friend of the court to do a petition or a recommendation for ordered on arrears amount that will be added so that we can make some headway towards this arrearage of $7,300. You'll have an opportunity at the end of the 8 weeks to object to that if you think it's inappropriate. But we'll have a hearing in 8 weeks to see how well you've been making your payments, and then we'll consider the ordered on arrears amount at that time. Ms. Spillane, is there anything else that you would ask the court for?
No, sir.
Mr. Brown, anything else?
No, Your Honor, thank you.
Ms. Lounsbury Burns, is anything else from you?
No, thank you.
All right, that's all for today. Thank you all very much.
Thank you.
Is there a Stanley Huffman with us?
Yes, there is. I'm so sorry. I apologize. So sorry.
What
I take full
happened?
accountability. That was
What
me.
happened? You didn't appear at 9 o'clock, Mr. Huffman.
My alarm didn't go off. I called the courts immediately as soon as I realized what time it was.
Ms. Spillane, is this Ms. Krause's case?
It is. I can go get her.
If you would, please.
Absolutely.
I called the friend of court too and left a voicemail too.
I'm here, Your Honor, sorry.
All right, Mr. Huffman has now managed to appear. I believe we issued a bench warrant for him. Was that correct?
Indeed, we did. I just actually had the person that he spoke with when he called pop into my office to indicate he thought his hearing was at 9:30, but it was actually, even if that was the case, it's now 10:15.
Right.
Bear with me just a moment while I grab the paperwork.
Yep, go right ahead.
Okay, thank you.
For the benefit of Mr. Huffman, would you update me on this file, please?
Yes, this hearing was adjourned from an arraignment hearing on October 27th. The bond would be reduced to PR bond upon $250 payment. That payment was received. He was to appear today. The defendant would be responsible for making payments until the income withholding is active. The defendant did report to our office on November 10th that he lost his job that he reported at the prior hearing. The second part of the conditions was the defendant was to contact friend of the court upon release. He did get out, but didn't have means to contact the office until November 5th. When he got a phone, he did call. There's been no additional payments besides the $250 that was made to be released from jail.
Mr. Huffman, what's your plan?
Currently, definitely, I've been putting in job apps everywhere I can. It's, I lost my job at Lisa's, I guess, apparently because she found someone that knew more than me or was actually experienced. So that's probably the third time I've lost a job because I learned too slow. But I am currently putting in job apps.
What was your job at Lisa's?
Cook. But she could only give me 2 to 3 days a week, and she was barely giving me that. God bless her soul for still giving me a job in general and allowing me to make the money I did make because it got me out of jail. So I still appreciate that.
So what's your plan going forward?
I do have have someone allowing me to do an oil change on their car today. So I might, hopefully, I can get that done today and I can make a payment to you guys today.
How much do you anticipate being able to pay today?
Probably not more than 100 because the oil change, I can't really charge over that much, especially when I'm not a full mechanic. I apologize to the courts too, by the way, for not showing up. I take full accountability for that.
All right, so you can pay $75 today. Is that what you're telling me?
I hope so.
Let's do that. We'll adjourn things out for 30 days. You're going to make 10 applications per week. And you're going to send those to the friend of the court each week. So on Friday of every week, they're going to get 10 applications from you until you get a job. And once you get a job, you're going to notify them of where that job is. Do you understand that, sir?
Yes, Your Honor.
All right, we'll adjourn this for 30 days to find out how you're doing. I expect a $75 payment today, 10 applications a week. And I'm hoping that you have a job before I see you again. Does that make sense?
Yes, Your Honor.
All right, that's all for today. Darian Yeager and Michael Richardson, file 24-19918-DS.
I'm here, Your Honor.
All right, thank you, Mr. Richardson. Appreciate your patience. Ms. Spillane, could you update me as to this matter?
Yes, sir. This matter was adjourned from October 24th to monitor the defendant's payment and search for additional employment. His monthly obligation is $416 with a current balance of $5,355.14. Last payment received was in October of $200.
All right, Mr. Richardson, how come you're not meeting your monthly obligation?
Right now I've been self-employed and I've been trying to find work. My truck broke down and then my trailer broke down, so I had a week without work. I just paid $200 today because I was able to find a job yesterday that I made $700. So I went down there first thing today and paid $200. That's what I had. I'm trying to pay at least $416 a month right now, but my monthly obligations with rent and other bills are exceeding more than I've been making the last 2 months. And right now I've been searching for other employment along with running my own business, but it's just everything's slow right now, and I've been trying my hardest that I can.
What do you do for your own business?
I do landscaping and handyman services. So like fall cleanup, tree work.
How long have you been doing that?
I've been doing that for the last almost 3 years.
Is that a cyclical business?
I don't understand what that means.
Means it goes up and down depending on the season?
Yes, sir. Like right now with the snow that we had the other day, things just slowed right down. I haven't got no phone calls in a couple days.
Were you pretty busy this summer?
Yeah, I was.
You put some money away because you knew that a slowdown was coming?
No, I had to buy a different truck and that recently broke down on me.
Sounds to me like you need a better budget.
I've been working on that.
So what are you doing to search for additional employment?
I've been calling other companies up, other construction companies, other landscape companies, been putting in applications, trying to find an overnight job.
How many of those applications have you put in?
At least 10, 15
In what time period?
in the last month.
I don't know if you heard me talking to another person on Zoom this morning, but typically I tend to tell people they need to do 10 a week, not 10 a month. If you're really hustling, 10 a week is easy. So I appreciate the fact that you're running your own business, but you've got to understand that it is a seasonal business and you're going to have these lulls and you got to plan for them. One way of planning for them is running a budget so that when you're making a lot of money, you're putting some of it away for the downtime. The other way of planning for it, and you can do both, is to have part-time jobs lined up ahead of time. It says if I'm slow in my first business, I can go over here and work at that job, or make plans to work for a month or two at a time at a fast food place or at a restaurant or wherever. You got to plan those things ahead of time. You can't just say, well, I hope it's going to happen. You got to make it happen. Ms. Spillane, what has his payment history been?
Honestly, not great. September, we received $1,500, but part of that was from bond. And then prior to that, it was in July for $500.
Mr. Richardson, in July, you should have been making bank, right?
I was dealing with other court issues that I wasn't able to make as much money as I had liked to back then.
you know that life happens, right? There's always going to be something that pops up and makes life hard to make your payments on, but people are still required to make their payments.
Yeah, I
You can't just
understand.
say, I'm going to pay the court last and then come to me and say, well, I tried. No, that's not how it works. Because you paid $200 today, I'm simply going to move this down the road for 30 days. You bought yourself 30 days. But I better see the full payment of $416 next month when we have this hearing. You understand what I just said?
Yes, sir.
If I don't see it, I'm likely going to consider contempt of court for failure to meet your obligations. You understand that as well?
Yes, sir.
All right. We'll adjourn for 30 days. Make your payment, find yourself some extra work on the side, or get yourself back going again on whatever job you think you want to do, but let's get it done. I'll see you in 30 days. Ms. Spillane, have you had any contact from Ms. Ball or Mr. Severns?
I did speak with Miss Ball this morning and she was intending on being present. However, she sent me an email during court indicating that she had been called into work and would not be able to attend. She did send me several screenshots indicating what she considers to be proof that the defendant does have an ability to pay something towards his child support.
All right, and you have a motion pending before me today for suspension of the defendant's license.
That's correct.
All right, why don't you tell me what you want me to do as to the license suspension?
I do know that Miss Ball would like to be present. And I do think that the grounds are there to suspend the license. So if you would like to hear from Miss Ball, I think if we were to adjourn it out, she would be present as she cites that she did not receive proper notice for this hearing today.
And you believe that she has information that would be necessary to show ability to pay and willful failure to do so?
I do.
All right, we will simply adjourn this matter out to allow Ms. Ball to appear and testify. Is there anything else that you want to do today?
I don't believe so.
All right, I will leave it up to you to schedule the next court date for that and send notices out to the parties, please. Is there something on the lens of your camera?
Maybe. My laptop broke, so now I'm having to use my phone. I apologize.
Ms. Ortiz, about the only thing I can see of you is a vague outline, and it looks like you're in a room full of smoke. Have you had contact with Mr. McCaleb about this motion?
No, I do not talk to him.
All right, well, before we get too far down the road here, let me get this case on the recording correctly. This is Ashley Ortiz and Morris McCaleb, file 23-19527-DM, set for a motion by Ms. Ortiz regarding parenting time. Could you repeat, Ms. Ortiz, have you had any contact from Mr. McCaleb about this motion?
No, I have not. We don't talk.
All right, and did you send a copy of this motion to Mr. McCaleb?
Yes, I did.
And you sent that to his Orchard Beach Road address in Sheboygan?
Yep.
All right. What is it that you want me to do and why regarding parenting time?
Okay, so I am asking that the parenting support be changed. I would like for Ava to stay living with me until she graduates high school. She moved in with her father when she was 14 and made poor choices while she was living there. She ended up in truancy school through Sheboygan County with Judge Bisnaugh. My daughter still continued to miss school almost every day. She got put on a tether. She got sent to lockup twice. She went to boot camp. Over the summer, Judge Bisnaugh ordered her to come home with me. She didn't want to live with me. He made her. And since she has been home with me, she's only missed a few days of school. She still is struggling in most of her classes, but I am communicating with all of her teachers. They're trying to come up with a plan to help her succeed. She has an appointment on Wednesday with community mental health to hopefully maybe get her on some ADD medication, and kind of just go from there. She started a job at Panera Bread, so I feel like we're kind of on the right track. I don't think it would be a good idea for her to go back to her dad's right now. And the last I knew, he had to leave. He recently got a divorce. So I think he had to move. He's not living at the Sheboygan address anymore. I'm not sure where he's at. So I guess I'm just asking that she stay with me until she graduates high school.
So you don't know whether Mr. McCaleb even got notice of today's hearing because you sent it to an address where you don't think he's living,
Well,
right?
nope, he did because he was still living there when I sent out the motion. It was supposed to go in front of the referee, Kyle Legal, and he said he didn't want to do that because he knows my brother, Kyle Ortiz, so it got reset to go in front of you.
Okay.
Um,
So the order of Judge Visnaw that Ava come live with you, was that supposed to be a make-up parenting time order?
No, that was just because she was doing so bad, living with her dad, and she wasn't going to school. She just kept getting in trouble and not following her probation officer's orders or Daryl's orders. So he ordered that she come live with me and try school here.
In your motion,
And
go ahead.
I was going to say, and I guess in our original parenting time order, we're supposed to like share summers, like 6 weeks. I get 6 weeks, he gets 6 weeks. But when she left to live with him when she was 14, I only got to see her like 2 times, and that was it. So he said, you need to go. Your mom gets you for 6 weeks, you're going there. And so she came here for her 6 weeks during the summer, and we were doing her online school, trying to get her caught up through her truancy school. And then he suggested that she just stay down here and try going to school here for the new school year because she was doing so poorly at her dad's.
He being Judge Visnaw in Sheboygan?
Yes. Yes.
So is there an order from Judge Visnaw that says that you are to have Ava at this time?
Yes, there is.
And was there an end date on that, or was that, why are you here if you already got an order from a court saying that Ava lives with you?
Because he's just her truancy judge. He's not our I don't know what it would be called. Front of the court is through you guys, Otsego County. It's not through Sheboygan County.
But it sounds like Judge Visnaw already changed.
And I guess it's still an open case though with him because we're supposed to have on the 19th, I believe, he rescheduled it to have a Zoom court hearing with Ava to see how things are going. And it was, he already postponed it before. I don't know, like a couple of times. He keeps changing the date. But
All right,
he
so how
wants
long,
to check in and see how she is doing.
how long has Ava been with you now?
She has been with me since, since he ordered her to live here permanently, that was August. But when she had come just for her 6 weeks that I was supposed to get, that would be in July.
So altogether, she's been with you full-time since sometime in early or mid-July?
Yes. Yep.
All right. And is there parenting time made available to the defendant, the dad?
Yes, he just never wants anything to do with the kids. Like he never calls or asks to see them. He's seen his son MJ probably twice in the past like 3 years. So I don't know. I've never kept the kids from him ever. He just never wants to see them or
And
call or
how-
check in or anything. So,
So you have two
and when
children.
he took Ava, because when Ava, she was her 6th grade summer. That's when she started kind of making bad choices. She went to go stay with her dad for his 6 weeks that he was supposed to get. And when the 6 weeks were up, I went to go get her and she refused to come home with me. And the police said they couldn't force her to go back home with me because of her age. And so that's when she started living with her dad. And that entire time that she was living there, he only let me see her like 2 times. And, and then that's just when she started doing really horrible, never going to school, making bad friends, and just, it just,
All right. And
problem
how is
after
Ava, how
problem.
is Ava doing in school now?
Well, she goes every day. I make sure she gets on the bus every day, but she's still not doing good. She's failing 4 out of her 6 classes. But I am communicating with all of her teachers, and we're trying to come up with a plan to get her to succeed. I don't know. It's constant. She lies all the time. So it's a struggle, but we're seeing a doctor. We're trying to get help for her. She's going to see mental health on Wednesday. She started a job, which I think might be good for her. Give her some accountability and responsibilities. I don't know. We're trying, but
All right. And Ava's brother is living with you full time. Is that true?
yes, yep.
Was there any siblings that lived with the father and Ava when she was there?
I guess so. A Gage. I'm not sure what his last name was. It was Ava's dad's wife's son, but I don't know what his last name is. Maybe Jacobs.
So a step child of the father?
Yes.
All right. Not a biological sibling of Ava's.
No.
All right. So the only biological sibling would be the child, the son that's in your home.
Yes. Yep.
All right.
And I apologize. His name is Morris too. Dad is Morris and son is Morris. So they have the same name. I apologize.
No, you don't have to apologize for that. Thank you for that
Okay.
clarification, though. Is there any other information that you want me to have?
I don't think so. I believe that's it.
All right. I will find that there is proper cause or significant change of circumstances that would allow the court to consider a change of custody motion in that the child has been transferred from the father's home in the Sheboygan area to the mother's home in the, you still live in Holland, ma'am?
Yes, I do.
All right, so to the mother's home in Holland, and the child has been with the mother for the last almost 4 months now, and has been there full time and has changed school systems in addition to that. So I do believe there's been a proper cause or a significant change of circumstances that would have a significant effect on the child's life, including custody change, basically a custody change from the father to the mother based on truancy decision of the court in Sheboygan County. I do find that there is an established custodial environment with the mother now. For the last 4 months, the child's been with her full time, and she is taking care of the child and making sure that the child is receiving appropriate schooling and care custody, including medical and psychological assistance, along with the school assistance. And then as to the best interest of the child factors. Because there's a established custodial environment with the mother, the burden of proof is the preponderance of the evidence. And then as to the best interest of the child factors, that would include love, affection, other emotional ties existing between the parties involved in the child. It appears that the mother has those with the child, and that the father has lesser amount of that because of his failure to contact the child over the last four months. Capacity and disposition of the parties to give the child love, affection, and guidance, and to continue the education and raising of the child appears to be in favor of the mother because of her actions of getting the child enrolled and making sure that she's not being truant. Even though she's still having difficulties in school, she is doing better at the educational part than the father was. And mother has also involved her in support services for mental health and psychiatric health as well. The next factor is the providing the child with food, clothing, medical care, and other remedial care and meeting material needs. It is apparent to me that the father has not done that over the last 4 months, and the mother has, so that favors the mother. The length of time the child has lived in a stable, satisfactory environment and the desirability of maintaining continuity. The child is now going to school on a regular basis and having their needs met for the mental health as well as physical health. Mom has the sibling in the same home, so it is providing a stable, satisfactory environment which the father was unable to do based on his difficulties in the truancy court in Sheboygan County. Homeschool and community record of the child also favors the mother because for the reasons I've stated previously about the schooling and the mental health aspects and truancy issues. And paragraph J, the willingness and ability of each party to facilitate and encourage a close continuing parent-child relationship between the child and the other parent. Mom has testified that she's not stopped dad from having any contact, but dad has in fact stopped having any contact. So it does appear that mom is willing to facilitate and encourage a close continuing parent-child relationship while dad has simply cut off the relationship with the child. For all of those reasons, I do grant the request for a change of custody. Mom and dad should have joint legal custody. Mom shall have sole physical custody with parenting time as the parties agree. And I will prepare an order and send it out to the parties. I will also refer this matter to the friend of the court for a child support recommendation. All right, that's all, Ms. Ortiz. Thank you very much.
Yep, thank you.
That later to do a proposed order. Last case on the docket for today is Nikolai Eimers versus Nicholas Eimers, file 25-20249-PP. I do note that Taylor Ostrom is with us as well as Nicholas Eimers. Ms. Ostrom is the next friend of Nikolai, who is age 2. This is a personal protection order issue. Petition was received by the court in October. The court issued a personal protection order protecting Nikolai from Nicholas. Mr. Nicholas Eimers has now submitted a motion to modify or terminate the personal protection order. Mr. Eimers, if you would state your reasons for asking that the court to terminate the personal protection order. Go ahead, sir.
Can you hear me, Your Honor? Can you hear me?
I can. Yes.
Okay. So I'm petitioning to get it dropped because for a lot of stuff. For like what she showed as evidence for me supposedly having this stuff happen and stuff, like, is completely false. And I have documents and statements that I submitted to you guys for you to look at, Your Honor, from my job, from my landlord, and like all the stuff that she's accused me of is false. And they even wrote statements to, you know what I mean, to show that it's a false statement that she's making. So
Mr.
I
Imers,
am trying
Mr.
to,
Mr. Imers,
yes.
hang on just a second. I apologize for interrupting you, but I need you to know that if you submit documentation to the court, that doesn't mean that I can look at it and consider it. I can only look at what's called evidence, and there are rules for what type of documents and what type of things can be admitted as evidence. Typically, a page or a picture or a document has to be admitted through the testimony of a witness to tell me what that page or that document is and who created it and why it's truthful. I can't just consider a letter from somebody without allowing cross-examination on that letter. And because the letter doesn't speak, there's no cross-examination available. So typically those documents are not allowed under the hearsay rule. So if you're trying to rely on a specific document, you're going to have to tell me what that is, where you got it from, and if it says what somebody else said, I wouldn't be able to admit that document. Do you understand all of that?
Yeah, I understand. I didn't know if they could come on here to testify and all that stuff. So that's why I submitted the documents. I did not know that I had to have them be here so you can cross-evaluate them to talk to them and stuff.
I appreciate that, and I'm not saying that you intentionally did anything wrong, but I wanted you to be aware that I can't review those pages just because you submitted them. I have to have a reason to do so, and it has to be admitted before me as evidence before I can consider it. So in your arguments, I'm going to give you a minute to finish your argument, and then we'll see what we do with the facts of the case after that. So go ahead.
Okay, never been accused or like prosecuted for anything towards my son at all. I work a full-time job. I work 6 days a week. I take care of my son. The only time Taylor Ostrom had my son is while I was going to work, and therefore back 4. So I left 2 days to go visit friends and family downstate, and I came back to these PPOs. Like I said, like this came out of nowhere, and so it goes down to the point of me and her are both on a lease to an apartment. And for her to get me out of that apartment, she submitted these PPOs so that I would become homeless and not be able to live at that apartment, even though I paid for that apartment. So this is what started all this and stuff. And like, she literally has statements from friends, you know what I mean, that I don't even know, Your Honor, to say all these types of stuff that is not true about me. And they've been harassing me even at my job, trying to get me fired. So it looks like, you know what I mean, I'm not a responsible father. And like I said, I even have people to witness this. She's been threatening to take my son away from me since that my son was born, Your Honor. And it comes down to it. Me and her had a 3-year relationship. We broke up for a couple months. She decided to run around and spend the night at other people's houses with her new boyfriend. And then she quit her job. She just got another job and stuff like that. While I've been working for the last year and a half, paying the rent, which I have actual evidence that I can submit to you in further time to show proof that I've paid for all this stuff. So my son is the world to me. I take care of my son the best I can. I give him everything he needs, clean clothes, everything and stuff like that. They are making it sound like I am the worst person on the face of the earth. And she's just, you know what I mean? This is a big exaggeration from her part.
Okay. Is there anything else that you want me to know?
No, Your Honor. That's majority of everything.
All right, Ms. Ostrom, how do you want to respond?
Sorry, I had to unmute myself. Can you hear me?
Yes.
Quick question before I start. You said that you can't enter into evidence letters without people being able to testify to those, correct? Is that what you mean?
Yep.
Okay, so if I have people who are able and willing to testify, the people who have wrote the letters, how do I go about that? Because I have the reason I got the PPO orders is because when I first met him, he was he had just come out of rehab and he was supposedly clean, and we got him a new doctor because he moved up from Lansing and stuff, and he had asked her for his Klonopin back, which I did not know what that was, so I minded my own business. And then he proceeded to start crushing multiple at a time, snorting them in front of me while I was pregnant. And then he would become extremely violent and stuff, and he stopped for a while. I figured he understood me. It was okay. Over the course of the 2 years we were together, he has hit me. He shoved me. He choked me out in front of our son to the point where Nico was screaming and crying. And then I got up. I went to go pick up Nico to leave. He shoved me into my son's pack and play, which my son was currently in, to the point where I fell over like a little stool we had behind us so I wouldn't hit my son's pack and play. Every single time that Nick had dropped Nico off to me or I had come pick him up, he was in soiled clothes, diapers that were so full that it was ridiculous. He smelled awful. He never got baths. He was always sick. He was only fed crackers and milk and bread, stuff like that. And ever since he's been with me, he's been clean clothes. I've bathed him almost every single day. I have pictures of him eating in his high chair. He's actually eating regular food now. I've gotten him to drink out of a straw. He's counting. He's saying his ABCs. He's actually speaking now. He's walking on his own with like us holding his hand, stuff he wasn't doing before. And the only reason that I did not call the police was because my landlord told me that if I called the police for any reason of domestic violence, we would both be evicted, and I did not want my son to lose his home. But Nicholas he stole my vehicle once and crashed it while on benzos. One time, because of that friend he was seeing, he came up and I had told him, I said, I do not mind if you hang out with your friend, but I would like you to get milk for Nico. Sorry, milk for our son. He told me he was on his way to the store. 4 hours go by. It's like 2 a.m. I had no vehicle. No, I did have the vehicle. I'm sorry. I did not have any money at the time or anything. So I went to go find him. He was knotted out in his friend's vehicle in the Meyer parking lot, and I pulled up to him and I said, you know, I need you to go get milk for Nico. It's too late now. He immediately grabbed me by the throat, told me to shut the F up, you effing B word. And I said, your son is in the car. You do not do this in front of him. You never put your hands on somebody, stuff like that. And I have multiple people to attest that Nico's doing so much better in my care. He's laughing more, he's playing more, he's more engaged with stuff. He's sleeping better, eating better, and like I said, I can have every single one that has written these letters. I don't know if you have them in front of you, that can testify on either, like, whenever you want to. They have told me they are willing to go on the stand for me and testify, because one of them is my mother, who Nicholas knows. We lived with her. She witnessed him being high. He crashed his Dodge that he has currently while high at Applebee's after being fired for selling, I believe it was cocaine, out of the bathroom. He has told me time and time again he can sell his benzos at Corwith Station to his coworkers for money. I told him, absolutely not. You never, ever sell your prescriptions, no matter how bad off we are. Multiple times I have had to ask my mother for help buying sippy cups, diapers, clothes for Nico. I've had to go to her.
Ms. Ostrom, let me interrupt you for just a second. What we're seem to be arguing about today from both sides appears to be who should have custody or parenting time of Nico.
I'm filing for.
Hang on. Let me finish, then I'll give you a chance to move on, all right? A personal protection order is a protection device where there's a belief that the other side of the person against whom the order is requested is going to put the protected person in danger. So the allegations that I looked at in your petition had to do with physical violence in the presence of Nico.
Mm-hmm.
What it sounds like to me is most of what this issue is a custody and parenting time issue. Mom wants to keep the child safe because she believes that dad is violent and using drugs. Dad says, no, I'm not. I want to see my son. And that's not what a personal protection order is for. It sounds like, Mom, that most of what you're alleging is that dad has been violent to you in the presence of Nico on occasion, but not that he has been directly violent to Nico. Would that be accurate?
He has ripped Nico out of my arms before, bruising his arm. He has never like laid, like, I would say he's never hit him, but I honestly 100% fear that if he has Nico alone and he proceeds, because I know he's currently staying at my Aunt Brenda's house and she has given him gabapentin, I believe that he's not a safe environment for Nico to be around. And especially with him not having a permanent place to stay, I don't know if Nico will have a place to sleep at night. He will be safe, fed, clothed. If a medical emergency happens, I don't believe he will be able to get him said care, stuff like that. I just don't feel like he is safe with my son, honestly.
And all of those issues tend to go to whether or not he should have custody or parenting time, not whether or not he's going to intentionally injure your son. And I understand that these issues are sometimes very close to each other. A personal protection order to protect the child could involve custody issues and parenting time issues, that he's not going to have a safe place for the child to go to sleep at. He's not going to take care of the child, physical needs or health needs. All of those could be, but they're not what the focus of a PPO is. A PPO is the child is in danger physically from the abusive actions of the dad or whoever the other party is. And so that there's an emergency requirement that the child be protected immediately, not an ongoing, hey, the dad is not got enough diapers, or the dad's not got a pack and play, or the dad's not got transportation for the child, custody and parenting time wise. So let me ask this. Mom, you have the child with you right now full time, is that correct?
Yes.
All right. Dad, when was the last time that you saw the child?
The last time I saw him was 3 weeks ago when she submitted the PPO. I've stayed away and followed everything I need to for this and stuff like that.
All right.
So
Hang
I
on,
just want.
hang on. Let me do this one step at a time.
Yes, Your Honor.
Have either of you filed any sort of custody or parenting time motion or request with the friend of the court's office?
I was
currently
going to
am
plan
in
on doing
process.
this right after this, as after the PPO. I was going to start that
so-
process.
So the answer is right now, no. Is that correct, Ms. Ostrom?
I have already filled out the paperwork. I am just waiting for a fee of waiver to file it, pretty much.
All right,
But
so you
Yeah.
haven't done it yet, but you're going to, and Mr. Eimer's basically the same answer. You haven't done it yet, but you're going to. All right.
Yes, Your Honor.
So that really is the most appropriate place for most of what you're talking about to be hashed out. And there's a relatively quick process for that to occur in front of the friend of the court referee, who can make a temporary decision on that until, if necessary, it comes before me under a full hearing. As to the issues of hitting and choking and shaking and shoving and all of that kind of stuff, that is an appropriate issue for a personal protection order. But really, it sounds to me, Mom, that as your issue is more, you're worried about Nico simply because he's violent to you when you have Nico.
Well,
would that be a fair way of saying it?
well, the one time Nick went to work and I stayed at the apartment and I was laying on the bed and I cut my leg on one of our kitchen knives and my son was carrying one around. Nick had hidden knives, our kitchen knives, all around the apartment. And then after I got the personal protection order, I was cleaning up the apartment because it had been trashed and stuff like that. My friend was helping me. She had caught my son with one of his medication bottles. It was like something he bought offline, but she looked it up. It was like something for your kidneys or something like that. So, my son had access to a bunch of pens, stuff like that.
All of
And
that is custody and parenting time. That's how he acts as a dad. That's how he cares for the child. It's not an emergency. Hey, he's going to injure the child tomorrow if I don't issue an order today. It's not that he's going to come over and beat the child up. The reason that I issued the personal protection order was because the two of you appeared to be out of control when in the presence of each other. And you were alleging that he was violent to you in the presence of Nico, so that Nico could be injured as a result of his violence in your presence and mostly towards you. Now that the two of you are separated, it appears to me that most of what you're still alleging is ongoing, not taking proper care of the baby. That is leaving knives around, that is having drugs around, that is, leaving the baby in a dirty diaper, having messes in the house. All of that kind of stuff is a custody and parenting time issue. What I'm hearing is that, Mom, you're still worried that Dad is going to hit or hurt you if the two of you were to be together. Is that accurate?
yes, and I fear that he's going to get angry with Nico because of everything that's going on.
All right,
because
so what? Hang on. So there are things called supervised parenting time where
Right.
someone else is present, and that would appear to me to be a way to limit his potential for acting out, for being intoxicated or on drugs or violent, that would protect Nico. So it appears to me that what we really should have is a PPO that protects you from him and stops that violent issues, and then allow the custody and parenting time to take place, that decision with the friend of the court. And in the meantime, simply say that while that custody and parenting time issue is pending, that we simply have supervised parenting time between Dad and Nico. Would that be sufficient for your needs, Ms. Ostrom?
I'm okay with that. Would he have to drug test or anything like that?
Well, I'll get to that in just a minute. I want to make sure we got at least an agreement in possibilities first. So, Mr. Eimers?
Your Honor, can I mention one thing real quick?
Yep.
The paperwork that you have for me that I submitted is a whole, like the last 4 or 5 months, because I go through substance abuse counseling and therapy and all that stuff. There's literally papers right in there that shows you that I have clean drops once a week. I haven't been on no type of drugs. So Miss Taylor Ostrom is all over the map with these knives supposedly being around places, and only her and her friend can see these, and a bottle that, supposedly is out of nowhere. I'm just talking about, it's like she's making up a bunch of stuff that's not true, and she's literally slandering my name. And you know what I mean? And to the point where, she's trying to get me fired. And I understand I can go through the front of the court, and I will get myself legal representatives for the front of the court, because like I said, this is outrageous of what she's saying about me. You know what I mean, Your Honor? And I'm being patient and politely, but I am not a violent person. I have never had any charges for being a violent person or hurting anybody at all. And all of a sudden this happened. And what I got to say is that I was with this woman for 3 years. If I was so abusive and bad like that, she could have, reported at any time, which she didn't, because it never happened.
I did.
And the fact is that, you know what I mean? She's using that because she thinks that's going to give her leverage over me, which is a sad thing to do, honestly.
Right.
So with
let me-
that, I leave it. Like I said, you have proof that I don't have any drugs in my thing for months. You know, the paperwork's literally right there that shows proof. So that's all I have to say. And if I have to, I will do supervised visits until I can get full custody of my son.
All right, so here's what I'm going to ask you, Mr. Eimers, specifically. My proposal to Ms. Ostrom was that there be a PPO that prevents you from having contact with her, but does not.
So there is already one in place. Okay.
Let me finish. Ms. Ostrom, is there a PPO in place with just you, with your name on it?
Yes, there is, which he's already broke. When we have a hearing on the 12th of December.
Stop. Answer my question, not continue to go on where you want to go. The question was, is there a PPO with your name on it? And the answer is yes. All right. So if there is a question of whether that's been violated, that's a different hearing. That's a different matter. It's not today. The only issue today is whether or not he should have contact with your son. And neither one of you have witnesses today with you beyond your own testimony. So
I
neither
do have
one
a
of
witness with me.
Who is
I
that,
have
ma'am?
two. I'm sorry. I apologize. I have two currently with me if you would like to speak with them. They would just
What,
have to
your
be on my phone.
your friend and your mother, like that doesn't give me a chance to get my witnesses.
Mr. Eimers,
Sorry.
this is not the street where you get to talk whenever and however and to whoever you want to. This is a courtroom and I'm in charge of it. So both of you, just tone it down.
Yes, Your Honor.
All right. I have not heard anything that leads me to believe that if there is supervised parenting time, that Nikolai would be in danger. I have heard things from one side that could be true and the other side that could be true. And quite frankly, it's the way that you two talk to each other. I don't know who to believe or what to believe. So it would be very difficult for me to sit here in judgment and listen to anybody have witnesses and anybody say anything simply because you guys have made your lives just such a mess the way that you lived it. You both have issues. You both have problems. It's time to start acting as an adult to each other so that I can say, all right, you are trying to do the right thing instead of just making allegations against the other side. It appears to me that Ms. Ostrom has had some issues with Mr. Eimers' violence. And for that, she has a PPO. I don't see anything that would need me to continue to have a PPO against involving Nikolai, where there is an ongoing custody and parenting time matter. So here's what I'm going to do. I'm going to leave the PPO in place for the next 30 days or so, and I'm going to reschedule today's hearing so that both of you can get whatever witnesses that you want to have here to be available to testify. That will give both of you 30 days to file custody and parenting time motions with the friend of the court. Once that process is begun, I think there's less need for a PPO in the future as to Nikolai, because the friend of the court can issue protective conditions about when he has contact with Mr. Eimers and under what circumstances he has contact with Mr. Eimers. And if Mr. Eimers is doing as well as he says he is with his sobriety and his drug testing, then he probably will get a certain amount of parenting time and can ask for custody if he wants to. But I don't think that this personal protection order is really the vehicle to deal with custody and parenting time of Nikolai. So I'm going to adjourn today's hearing for 30 days. At that next court hearing, if custody and parenting time is being disputed in the friend of the court's office, I'm likely going to take the PPO off of Nikolai. So one or both of you needs to file your motions. And then the friend of the court and the referee can do the protections that Nikolai needs under those issues. If for whatever reason, custody and parenting time is not protecting Nikolai, I will have a full hearing in 30 days on this current PPO against Nikolai when both sides have all of their witnesses present and available. So we'll set it for 2 hours to allow you to have time for that. Do either of you have any questions about what we're doing today?
No, Your Honor. I will have everything ready. I just need to know when the court date will be to do this.
And I don't know what that is today because I don't know what this court schedule is in order to find a 2-hour period of time to give that to you. So the clerks will find that date and time and they will send you the notices in the mail. If you have not received that within the next 7 days, contact the court's office. Yes, Mr. Reimers.
My address is at that apartment, so any mail that's sent there, I will not be able to get.
Where do you want us to send it to?
Is there anywhere I could just pick it up or make a call?
You can
Because I don't
call
have a
clerk.
PO box or anything like that right now.
Ms. DeFighter, would that be set through my clerk's office here, or was that through you?
No, that Samantha would be setting that, but he's more than
All right.
welcome to call and we can get him a copy. That's not a problem.
Yeah. Well, he can call here as well.
Thank you, Your Honor.
What number do you want him to call?
You can call mine. 0205.
731-0205 and ask for Ms. Johnson. That would be the number that you would be able to get notice of the hearing date next. And you probably want to wait until Monday afternoon or Tuesday before you make that phone call because she's going to be in court. She has been in court all morning with me. And she may not be able to get that accomplished this afternoon. Do you have any other questions, Mr. Reimers?
No, sir.
Ms. Ostrom, do you have any questions?
Pretty much just like if he has to contact me in any way, I'm asking if there's a way that I know that there's a court messaging system. Like I would ask that we go through that for the parenting time or the supervised visitations or however
Again,
that works.
Okay, Ms. Ostrom, you're again confusing a personal protection order proceeding with a custody and parenting time proceeding. I am not the judge right now that can make orders on a custody and parenting time issue because neither one of you have filed a request for that. So right now there is no supervised parenting time. There is no custody. There is no order regarding parenting time at all. The only thing that's in place is this personal protection order, which is designed to prevent, to act as an emergency safety net where there's allegations of abuse or physical injury or physical abuse. So that's why I want to give you each the opportunity to start the process with the friend of the court on the custody and parenting time so that you can begin to have those kinds of orders put into place. And then we'll come back in 30 days and see whether we continue to need the personal protection order or not. And I'm telling you that once the custody and parenting time system is in place, as to Nico, the PPO will likely be taken off. But right now I'm going to leave it on just because the two of you have such a difficult time discussing anything with each other. All right.
Okay.
Now, do you have additional questions?
No, thank you.
All right. So you both will get notice in the mail of when the next PPO hearing is. If we're going to do that hearing, have your witnesses available. Most likely, we're not going to do that hearing if you've already done the custody and parenting time orders or motions. All right, that's all for today then. Thank you all very much.
Okay, thank you.